My name is Josh Cohen, and I'm looking forward to giving my own presentation tomorrow morning. But for now, it is my pleasure and privilege to introduce Professor Anita Allen, who is Professor of Law and Philosophy at the University of Pennsylvania, an expert on privacy law, on philosophies of liberalism, and on feminism. In the run-up to this session, I've been reading her book, Unpopular Privacy, What Must We Hide? She's also, I should say, the author of Uneasy Access, Privacy for Women in a Free Society, and a number of other books around the intersection of privacy law, feminism, and democracy, and very much at the interface of legal studies and philosophy. But I was fascinated reading Unpopular Privacy in a paradox that's actually come up repeatedly in the course of today's discussion, which is something like compromising privacy in order to protect it. Somebody spoke earlier of needing a kind of, one kind of exposure to fend off a worse kind of exposure. Unpopular privacy is almost an oxymoron as a term, insofar as privacy is understood by so many of us intuitively as having at its heart private choice, will, desire. Anita Allen raises the question of whether there is a justification for overriding the will of the citizen in the name of their privacy. In other words, overriding their private choice in the name of their privacy. Is there a dimension of privacy then other than choice that we should be valuing more than the autonomy to make decisions? One of the most interesting examples she uses in developing this question is she offers a hypothesis of a piece of legislation which would prevent anyone under 18 from giving away any of their data. They wouldn't have that personal choice. They wouldn't be able to give any of their data away online. I think this introduces some fascinating knots, both legally but also philosophically, at the level of ethics, at the level of the kinds of questions we were asking in the previous session about what kind of selfhood we want to cultivate. And is it possible to use law and to use a system of values to actually force or railroad a certain kind of culture and cultivation of the self? This evening, Anita will be addressing another issue that's come up repeatedly in discussion, the home as the crucible of privacy. And her title is intriguing in this regard. She's talking about the home as public and private. Anita.
Thank you, Josh. I appreciate your introduction. And I am indeed talking about the home this afternoon. And I think that my concerns really do kind of, in a way, pull together the entire day's discussion, although I had no idea of that when I decided to write this talk. My talk is inspired by an artist named Svendsen, a New York fine arts photographer who took some pictures of his neighbors. He got sued for it and went to court. And he won, but he shouldn't have won. And this entire lecture is sort of about building the case against Arnie. Okay. Although the home is not a guarantor of repose, we know that, the home is often the heart de facto of private life and a domain culturally marked for the enjoyment of the highest expectations of privacy. The desire for privacy often drives legal complaints about the scope of police searches and seizures, voyeurism, trespass, ambush journalism, revenge porn, big data analytics of our quotidian lives, and the expanding Internet of Things. When it comes to articulating the significance of a private sphere in association with the home, no one has surpassed Hannah Arendt in insight, or for that matter, in error, about the sanctity of the hearth. In her book, The Human Condition, she narrates an ancient history of the Western world, according to which we are driven together behind the walls of the oikos, the household, by biological wants and needs. Our escape from necessity into the world of the polis, the city-state, depending upon our having achieved in our household, in a household of one's own, grand enough accomplishments to define us as human beings, really males, aristos, worthy for participation in civic governance. The idea of a household whose physical walls define political limits and opportunities came to North America as an Anglo-European transplant. This transplant was used, ironically, as ammunition against British colonial authority. A Massachusetts lawyer and inspiration for patriots of the American Revolution, James Otis is chiefly remembered for a 5-hour speech he delivered in Boston in February 1761. It was an oration in Paxton's case against the issuance of certain writs of assistance. When issued, the writs that Otis objected to would allow British officials broad and long-term authority to enter and search the colonists' private homes and businesses. Otis asserted in the famous speech that, quote, "One of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he's quiet, he is as well guarded as a prince in his castle." And the slide shows one of my favorite castles in southern Italy, in Puglia. One's home is secure and private and necessary for liberty. That's the trope. So history remembers Otis's venerated pronouncement that a man's house is his castle, but it is tended to forget his qualifier. I call it the Quietude Qualifier, that a person in his castle is well guarded only whilst he is quiet. The freedom of one's house is interpreted by Otis as both essential and is not absolute. For once a man or a woman at home fails to be quiet, they cannot expect to be let alone by others. They invite entry and intrusion. As a general matter, this analysis of the privacy of the home makes sense. Imagine that I'm leaning out of my window, shouting obscenities at passerbys. Well, then those people might shout back, throw things at me, or call the police. Who could blame them? If I persist, the authorities are justified in coming into my house to investigate the cause of my antisocial behavior. They might even be justified in arresting me or taking me to a hospital. I am not being quiet. I have therefore forfeited the freedom of my house. I have called attention to myself, signaling that I do not want the privacy that comes from homes generally. Or suppose I throw a party, blasting loud music into the night. Here, too, the authorities may penetrate the curtilage, come inside my dwelling to check things out. The police would be warranted in coming inside a rowdy house to issue a warning or break things up for the night. Why is the interference warranted? It is warranted because the occupants are not quiet. By being noisy, one has forfeited the freedom of one's house to which one otherwise would be presumptively entitled. But the failure to be quiet in the literal, oral sense is not the only condition that qualifies the privacy of the home and virtually explodes the home for public access and inspection. Otis was surely making a larger point that our Anglo-American legal tradition calls for strong protection of the home, hence his castle metaphor, but subject to cooperative self-concealment, our not being a nuisance to others, and our being affirmatively law-abiding, hence the Quietude Qualifier. This is an actual photograph taken yesterday of the scene from my front door. This is my neighbor's house. Notice it's a Frank Furness barn turned into his fantasy of a castle, right? And in my neighborhood, one can never have a house that's large enough. It has to be constantly made. Everyone wants their house to be like a castle. And if your house is like a castle, then you have more privacy, right? In a free society, everyone should be able to protect the freedom of their houses, meaning the privacy of their homes, privacy while at their home. The Fourth Amendment warrant requirement enshrines such an ideal. Moreover, an international home is castle ideal is symbolized by a panoply of documents, including the influential Article 12 of the UN Declaration of Human Rights, Article 17 of the International Covenant on Civil and Political Rights, Article 8 of the Council of Europe's Convention for the Protection of Human Rights and Fundamental Freedoms, and Article 7 of the Charter of Fundamental Rights of the European Union. These international documents decry, quote-unquote, arbitrary interference with or attacks on privacy, on family, on home, correspondence, communications, along with attacks on honor and reputation. Quote unquote, everyone has a right to the protection of the law against such interference or attacks. As in the US, in Europe, a person's home is supposed to be a castle. Parties have appealed to Article 8 of the European Court, appealed to Article 8 in the European Court of Human Rights cases to defend a wide range of interests tied to homes. The court has held, for example, that the trailers that the Roma of Europe live in are actually homes for purposes of the international standard. In another case, the court actually found that there's a right of privacy against pollution, against the pollution that might prevent one from enjoying one's home and being healthy in one's home. So there's a very wide application in some contexts of what it means to have the right to privacy of the home. While accepting the home as castle principle, most people in the US and in Europe and the UK simultaneously embrace a pragmatic quietude qualifier. The quietude qualifier is a cornerstone of the way American law and the judges who interpret it have tended to think about the privacy of the home. Under the qualifier, one no longer merits privacy protection against interference or attacks when one either breaches the peace in some way, or becomes a danger to society, or exposes oneself voluntarily, signaling to others that one is willing to be known, seen, heard, smelled, or felt. So if I hide a body in my basement, I'm no longer entitled to privacy. If I throw a lively, loud holiday party for the neighborhood, I'm no longer entitled to privacy. All right? So far it all sounds kind of like, okay, well, the only thing you have to worry about is whether or not you are, in this broad sense, quiet. Be quiet, and you've got a lovely right to privacy in your home. But this is not so. In a suggestive analysis, Ken Kirsch has argued that the American state, different now from both the rural and agricultural and the urban and industrial state, is now what he calls a corporate administrative capitalist state whose success depends upon detailed knowledge of who and what it must manage and control. On this theory, anything invisible or in a dark corner is a potential threat or impediment. Granular access to personal life is in the interest of the state. Thus, we could expect the quietude qualifier to be subject to expansive and permissive interpretations that free the hands of industry and government. What gets defined as harmful to society could come dangerously close to knowing no bounds. What counts as a voluntary waiver or forfeiture of privacy could come perilously close to being considered just about anything anybody does that increases accessibility to another human being. Thus, if I want fulsome privacy, I have to worry if I'm quiet enough, but also whether I am useless enough. Useless enough. Because no matter how quiet I am, in today's world, I cannot expect privacy if knowledge about me may be useful to other people. In an article in the June 28, 2015 New York Times about U.S. national security laws, the Foreign Surveillance Court and the Obama administration, the author pointed to what he felt is a trend in thinking about surveillance rules, that anything useful to government has come to be fair game. Case in point, telephony metadata. Quote, the author, because massive sets of metadata are useful, they are relevant to public order, even though they draw exclusively on the private lives of innocent people, they're accessed, they're gathered. Now, is it as bad as all of that? Does whether I am quietly law-abiding and self-concealed matter anymore to whether my privacy will be protected if the details of my private life are useful to others? Does the presumptive status of the home as castle yield whenever breaching our walls is useful to the government, to business, or to a fellow citizen with more clout? Well, the James Otis of today could be reduced to saying, a man or woman's house is their castle, and whilst they are quiet or of no use to government or big business or more important people, they are as well guarded as a prince or princess in their castle. I'll come back to this. Louis Brandeis, this is my photograph of Louis Brandeis as depicted by Andy Warhol. So the home as castle trope, you might say, is deep inside of old law and new law. Homes, exclusive, secure, private. In the United States, our Supreme Court has issued many important decisions in which they stress the importance of the privacy of the home and the measures that individuals and the state may take to protect it. Justice Louis Brandeis was among the first jurors to emphasize the importance of limiting access to the home and to telephonic communications with an expectation of privacy. He forewarned in Olmstead versus United States in 1928 about the technologies that would threaten the home. Discovery and invention have made it possible to obtain disclosure of what is whispered. Ways may someday be developed in which what is whispered in the closets may be shouted from the rooftops. The most intimate occurrences of the home will someday be disclosed by technology. Pictured is Louis Brandeis' summer house. He liked the home too. The Fourth Amendment, Brandeis felt, was an important constraint on official uses of technology to invade the home. Brandeis, again, whose summer home is depicted here, is aptly considered, I was going to say the father, but I'll say the parent of American privacy, for his, pardon the pun, seminal role in articulating the need for a common law right of privacy to protect what he called the sacred precincts of private and domestic life. The language Justice Brandeis used to describe privacy as a constitutional value in his Olmstead dissent, attacking warrantless wiretapping, strongly echoes the language he used earlier, 30 years earlier, to describe privacy as a common law value in the opening paragraphs of his law review article in the Harvard Law Review with Samuel Warren. In both places, he speaks about man's spiritual nature and regard for his feelings and his intellect and inviolate personality. And he was concerned about instantaneous photographs, we've heard this before, newspaper enterprise invading the sacred precincts of private and domestic life, numerous mechanical devices threatening to make the prediction that what is whispered in the closet shall be proclaimed from the housetop. Okay. And he was right. This is a drone. So, the garden used to be a place you could go to contemplate nature and be alone. But now you go into the garden behind your gigantic castle-like mansion, and a drone might follow you there, right? So even the garden is no longer a place where one can be sure of privacy. But I think that Brandeis understood things quite well. The opinion of Justice Andrew Jackson Cobb in the first U.S. state Supreme Court to recognize the right to common law privacy in 1906 compared the privacy invasion of using someone's photograph without their permission in an advertisement, in this case an advertisement for life insurance, as being like a merciless master dragging his slave into the public streets against the fibers of his will. Why does privacy matter? Why does liberty matter? That's your answer. So this was a case, this is the advertisement in question. This robust-looking man on the left was a random artist living in Atlanta. Someone took his picture without his permission and used it in an advertisement. He sued and he won because for the first time in history, a state Supreme Court and a particular judge was willing to say that, yes, it is an invasion of our privacy to take our pictures and use them without our consent. And it was remarkable that in making this decision, Judge Andrew Jackson Cobb decided to analogize invasions of privacy to slavery. And it's very important because Justice Andrew Jackson Cobb was not using slavery in some like metaphorical sense, because he had been himself raised by slaves. His father owned slaves, his grandfather owned slaves, his uncle owned slaves, his uncle wrote the Constitution of the Confederacy. So he was being very, very literal and serious when he decided to draw upon the horrors of slavery to help us understand that we're really depriving someone in some very basic way of freedom when we decide to use them for our own purposes. Use them for our own purposes. Now, the U.S. Supreme Court has emphasized that the privacy that we have is not limited to the home. It even applies to conversations in phone booths. But the justices' rhetoric and holdings elevate the home as the place where the strongest privacy rights obtain as against the state and private actors. For example, in Stanley versus Georgia, Justice Thurgood Marshall argued that we even have a right to do illegal stuff as long as we're doing it inside our house. So in this particular case, Stanley versus Georgia, it would have been completely illegal for anyone to sell obscene materials outside the house or to have them on their possession outside the house. But because, oh my God, I'm really excited. Because Mr. Stanley possessed his obscene videos in his house, reel to reel, in his house, in his closet, he could not be criminally prosecuted. That's what the home means, right? And more recently, the Supreme Court has found that the government cannot engage in warrantless thermal imaging of our homes. They can't come to our homes with thermal imaging devices and spy upon us in that way. And the court, Justice Scalia, he clearly feared that thermal imaging might reveal, as he put it, the details of the lady in her bath. My God. Not that, right? The lady in her bath. But this, and then Justice Scalia later, just to show how broad his conception of privacy is, he later, in the Heller case that struck down D.C.'s gun laws, he appealed to the home to justify why we couldn't have gun control. Because after all, people need to be able to protect their homes by having loaded guns or guns in their house. Right. So this is a very broad right. The Supreme Court's also defended the home in a case involving abortion protests. So the court found that abortion protesters could not go to the homes of abortion providers because residential privacy is an incredibly important constitutional interest. So our Supreme Court, elevates the home, uses the home whenever it feels like it to justify all kinds of important interests and rights, some of which we agree with, some of which we don't. One might agree with the abortion case, but not with the gun case. And then, in our gay rights cases, the Supreme Court appeals to the home. It was appealed to the home in the Lawrence decision, which decriminalized gay sex. In the recent Obergefell decision, once again, the home is a centerpiece of the court's analysis, that central trope. So equal dignity of marriage allows same-sex couples to create and enjoy homes of their own. So Justice Kennedy wrote, quoting President, "The court has recognized as a unified whole the right to marry, establish a home, bring up children." This is a central part of the liberty protected by the Due Process Clause. Interestingly, several years before Obergefell, Professor Carlos Ball argued that our courts, he called it geographization of sexual liberty, has resulted in the protection of sexual conduct that takes place in the home and in analogous sites like hotel rooms, while leaving unprotected sexual conduct, consensual, adult, that takes place in places like bathhouses or bathrooms. Bell talked about how our old laws, which banned homosexuality from the hearth, forced gay people outside, and yet protected neither gay sex in the house nor gay sex outside the house. Does Obergefell correct that problem? Not exactly. It just confers protection upon things which happen and are associated with the traditional home. So we still have this kind of geographization of privacy represented by the continued association of all that is good and sacred with hearth and home. Now a dose of realism. We all know that the ideal of the privacy of the home is at odds with reality. Too many people do not have homes at all. Just look around Paris or Washington, D.C. on the streets. People are sleeping outside. The condition for people inside the home is not a condition of meaningful solitude due to sharing and caregiving and domination and control, right? I mean, this is old stuff for feminists, old knowledge, not new knowledge. We've heard today about E.L. Godkin and all kinds of other 19th century thinkers. I don't think I've heard Charlotte Perkins Gilman's name mentioned today, but she was that utopian feminist who wrote a book called Women in Economics, had a whole chapter on privacy. And her concern is that, people value the private home, that's really great, but what happens inside the home? If women are busy, with their bric-a-brac and cooking and taking care of babies, even though they have the home, the private home, they do not enjoy the experience of privacy. And this is actually why I'm so intent upon this notion of coercing privacy and paternalism, because we have to make sure people have the experience of privacy, not just the formal structure of privacy, but if privacy is important, people actually have to have the opportunity and to have real privacy and the ability and the desire to pursue it. All right, the declining significance of the home. The castle metaphor and myth live on in jurisprudence and in ordinary life. And so does the Quietude Qualifier. But there are important questions suggested by recent legal disputes about how we understand the condition of quietude that should protect us from interference or attack. When is a person in her home really protected from assaults on privacy? In the age of social media, revenge porn, metadata collection, big data, Internet of Things, in this world in which even our refrigerators and our televisions will be talking online to the outside world, what kind of privacy of the home have we not forfeited? Moreover, the common law of privacy is telling us that being quiet doesn't matter if we are useful. Utility to business, government, or other people can render our right to privacy null and void. And now some examples. I love this work of art by an African-American artist named Bill Traynor. Utility qualifier. Utility qualifies our privacy. So there's this family called the Boring family. That's literally their name. Boring versus Google. Some of you know this case. So this is a family who brought a lawsuit against Google. They didn't want Google Street View coming onto their private property to photograph their house. They lived on a secluded private road. But Google drove their little car onto their private, secluded road and started taking pictures of their house. Well, the Boring family sued Google for trespass and for invasion of privacy. And after a long, long series of lawsuits and cases that went on for 3 or 4 years, the Boring family, they won a little bit. They got $1, literally $1 US, for the trespass, and the privacy claims were thrown out completely. So why were the privacy claims thrown out completely? Well, the court found that, quote, no person of ordinary sensibilities would be shamed, humiliated, or suffer mentally as a result of a vehicle entering his or her ungated driveway, right, and photographing the view from there. Indeed, the privacy allegedly intruded upon was the external view of the Boring's house, garage, and pool, a view that would be seen by any person who entered onto their driveway, including a visitor or a delivery man. Thus, what really seems to be at the heart of the complaint is not Google's fleeting presence on the driveway, but the photographic image captured at that time. The existence of that image, though, does not in itself rise to the level of an intrusion that could reasonably be called highly offensive. Their claim for intrusion upon seclusion fails as a matter of law because the alleged conduct would not be highly offensive to a person of ordinary sensibilities. We are at the mercy of what our courts will deem to be highly offensive to a person of ordinary sensibilities. That's the technical legal standard. Highly offensive to a reasonable person. Who is that person? Well, it could be an opportunistic straight guy in an intolerant community. Example, Plaxico versus Michael. This is a while ago, but my point is not to give you not so much the current state of the law, it's to show you the risk and tensions in our law. So it's about 1998 or so, and Rita Plaxico is in her own house, in her own bedroom, having sex with her own girlfriend. Girlfriend's ex-husband drives up to her house, goes to the bedroom window, sees some sex going on, runs to his car, gets the camera, takes photographs of the sex, goes running off to family court. See, my ex-wife's a lesbian. Give me the baby. Right? And guess what? He gets the baby. He gets the child, gets the daughter. Right? Now, Plaxico, who's not part of this little family drama at all, she's just the girlfriend of the ex, she brings a lawsuit for invasion of privacy. She should win, right? I mean, this guy, he loses. Why does she lose? It's astonishing. She loses because the court found that reasonable people would feel that Michael's actions were justified in order to protect the welfare of his minor child, and therefore the elements necessary to establish the tort of intentional intrusion upon seclusion or solitude were not present in the case. Now, these two cases, the Boring versus Google case, Plaxico versus Michael case, show that even when we're being quiet, minding our own business, our castles are not necessarily protected by law. The big firm like Google or our lover's small-minded ex-husband can get away with using us for their own purposes. And artists can use us for their own purposes too, a point illustrated by the recent case Svendsen versus Foster. What you see here is a piece of architecture. It's a building in Tribeca in Manhattan called the Zinc Building. It's a luxury condo building. Sun-drenched loft, according to the advertisement. You know. And so Arnie Svendsen is a fine arts photographer who lives right across from this amazing structure. And his photographs, he's a very well-established, internationally renowned fine arts photographer. And according to court documents, in 2012, a friend of his, who was a bird watcher, gave him by chance a telephoto camera lens. Svendsen then used the lens to photograph the people in his village, harkening back to this morning, in his village living in the Zinc Building. Now, the condo, as you can see, has largely glass facades, and each apartment has very large windows. The arrangement of the windows is reminiscent of the iconic paintings of Mondrian, right? So, the photographer looks up, Mondrian, I can do something with that, right? So for about a year, Svendsen photographed the Zinc Building residents of all ages without their knowledge. He eventually selected some of his pictures for display in Los Angeles and New York galleries. The collection of photographs was appropriately named The Neighbors and were advertised for sale. Now, one might suppose that such a project raised major privacy concerns for the artists. But instead, as recited in court documents, in the artist's promotional materials for his exhibit, it said that for these subjects, the people, the neighbors, there's no question of privacy. They are performing behind a transparent scrim on a stage of their own creation with the curtain raised high. Discounting privacy concerns, Svendsen has explained that his subjects did not know that they were being photographed, that he took care to remain in the shadows within his apartment, like that Alfred Hitchcock movie, right? He's hiding, not letting them. But okay, so he's trying not to be seen as he's spying, and that for him is a defense against privacy claims. At one point, he had a New Yorker magazine journalist join him in this fun as he surreptitiously photographed people, including, quote unquote, a little girl dancing in her tiara, half naked. Now, some of the neighbors brought a lawsuit against Svendsen, but the pictures are gorgeous. This is one of them. It reminds you of a Dutch painting. They're beautiful, no question about it, a beautiful photograph. And this one, the person who's photographed, you can't see his face, so, one might think, well, where's the privacy concern, right? A boy reclining on a sofa in the window, his face isn't showing, right? Although he recognizes himself, you and I don't know who he is. We know where he lives, though. A woman bent over, what's she doing? Maybe she dropped her pearls. Maybe somebody slapped her in the face and she fell to the ground. We don't know the story, but, it's a beautiful photograph. Undeniably gorgeous photograph, right? So the lawsuit against Svendsen was brought by a family whose children had been photographed. And I think, one thought, well, if anybody can win, the family with the kids might win. And Svendsen did decide to take out of the exhibit some of the photographs of children. But the lawsuit moved on. There is in New York a very interesting law that was enacted way back at the turn of the century. And it was the first sort of state statute protecting privacy. This law, New York Civil Law 5051, makes a person civilly liable for the appropriation of others' name or likeness for commercial or trade purposes. So isn't this appropriation of somebody's name or likeness for commercial purposes? I mean, isn't that what this is? Well, the court said no. The Zink neighbors lost their case and lost again on appeal. Just this last spring, the final decision was made by the appellate division of the New York State Court. And the votes were unanimous. Unanimous in the lower Supreme Court, unanimous in the Court of Appeals in New York. Neither taking the picture, exhibiting the pictures in the gallery, nor advertising the exhibition and availability of the pictures for sale was an invasion of privacy under the statute. What the court said was, quoting the court, defendant's use of the photographs falls within the ambit of constitutionally protected conduct in the form of a work of art. Indeed, the court goes on, plaintiffs concede on appeal that defendant, a renowned fine arts photographer, assembled the photographs in an exhibit that was shown in a public forum, an art gallery. Since the images themselves constitute the work of art, and artwork is protected by the First Amendment, any advertising undertaken in connection with the promotion of the artwork was permitted. Thus, under any reasonable view of the allegations, it cannot be inferred that the plaintiff's images were used for commercial or trade purposes or advertising within the meaning of the statute. Defendant's conduct, however disturbing it may be, cannot properly, under the current state of the law, be deemed so outrageous that it went beyond decency and the protections of the law. To be sure, by our holding here, we find no viable cause of action for privacy, but we do not in any way mean to give short shrift to the plaintiff's concerns. Undoubtedly, like plaintiffs, many people would be rightfully offended by the intrusive manner in which the photographs were taken in this case. Now, other voyeuristic artists have also gotten away with similar things. And by the way, the complaint here is not that somehow bedrooms or intimacy is off limit for artists. We love art like this Van Gogh painting. We love art that depicts the intimate. We even like art that's very graphic. I'll just show you one quick graphic, you know this work, this one, in Paris, the Origins of the World. I mean, the complaint is not that somebody's vagina was on display. The point is that real people's who were not models were taken and turned into art against their will, as was this woman. Here we have an artist, Michael Otter, who took video of people from his window through theirs, and he captured in this instance a woman who's getting out of the shower. And he just doesn't see this as a privacy problem. He has analogized himself to a wildlife photographer, right? Just as people go, off to the Amazon or to Africa and take pictures of the wild beast, so too he photographs the human beast, right? No difference. Why should he be disabled from doing what people can do with animals? Now, I met a graduate student at Cornell last summer at a critical theory workshop who had a very interesting twist on this case. It made me think, maybe I was wrong. So her view was this. She said, privileged rich white people living in chic glass apartment buildings have purchased the right to be seen conspicuously consuming Manhattan. Joke on them, right? Joke's on them that somebody dared to take their pictures. They assumed that nobody would dare to take a picture of them living their lives, again, in their chic little glass houses. Why should we care about an affront to such privilege? Well, this tempting write-off cannot be correct. Glass architecture and windows don't end people's entitlement to sunshine and fresh air. Enjoying light from within an apartment in a city cannot be deemed an utter forfeiture of expectations of privacy. When was that made the social ethical norm? Do we really want people to have to live in darkness and without light behind curtains? Is that how we want people to live? The Foster neighbors lost their case against Svendsen because they were useful to Svendsen. The neighbors were useful to Svendsen in the production of art qua art and art qua commodity. The Borings were useful to Google in the production of a commodity, Google Street View. Plaxico was useful to Michaels in the preservation of heterosexual hegemony. Home, as Castle says, homes are private, exclusive, secure, but homes are not private, they're not exclusive, they're not secure if the lives inside are deemed not quiet and quite useful to the right people and institutions. People like the neighbors and the Borings and Plaxico are, to differing degrees, dragged out of their homes and made subject to the gazes of others. Privacy invasions can feel like and be coercive limits on liberty. The victim of a commercial appropriation of likeness is like a slave to a merciless master. Why does privacy matter? It's the opposite of slavery. It's potentially the opposite of slavery. Of course, we know privacy can facilitate slavery, and it did. We know those old cases, State versus Mann, et cetera, where the courts upheld that it's okay for people that people couldn't be punished for beating their slaves or their wives because it's all about privacy. Private sphere. Don't want to bring that out in public sphere. But putting that aside for just a second, right, because we've now hopefully gotten beyond the worst of that, potentially our homes can be places where we can experience something of that room of one's own autonomy and agency, some of that contemplative seclusion and solitude that was talked about in the earlier panel. Some of that's still possible. Some of that stuff Hannah Arendt talked about is still possible. But it's not possible if our homes are going to be, like this image, exploded for purposes that are different from and beyond our own ends. And I'll stop there. Should I come and sit?
Anita, that was a wonderful provocation. It was so lively and so stimulating. So I'm sure we'll have a lot of people who have questions to ask. I just want to, it seems to me that one of the things that you're doing in terms of the ethics and politics of privacy here is to get us talking about instrumentalization, which I think is what you feel was missing from Arendt's account and from this kind of more generalized discourse of the home as castle. That the problem is it's missing a tendency of outside agencies to instrumentalize, or outside forces to instrumentalize the home and the people in it. Can you say a bit more about that?
Yeah, and it is just a matter of emphasis. I found that lots of people today were making similar points about the exceptions to privacy rights and privacy norms. And I guess I'm tempting here to underscore this idea of utility, because I do think that I guess it's probably the Kantian in me a little bit that wants to have people treated as subjects and not so much as objects. But yet the law readily will convert subject to object when the object fails to be quiet or is useful. And I think it's very important to pull that out and to really look at that and examine that and ask ourselves, do we really want to buy into the quietude qualifier and the utility qualifier to that extent? And I think these court cases show some shocking and maybe some more understandable examples of that. The Google case, maybe it's not so bad, but the Plaxico kind of a case, or the Svendsen case, raise real problems about how we want our judges to think about privacy. I have many friends who are judges, and I admire our judges and our judiciary tremendously, but I really don't think that the courts as a whole in the United States understand why privacy matters. And events like this one and its products can help to educate not only our students and our colleagues and ourselves further, but also the bench and the bar.
So there are a lot of cracks in this castle. One of the implications of your presentation is that it's not quite clear really whether we can conflate the home and privacy, which is, again, something that Arendt seems to want us to do. You seem to be saying that actually, first of all, the walls around privacy are not secure. The walls around the home are not secure. And at the same time, that privacy actually can't be confined to the home, that it spills out into all kinds of other contexts. So, for example, why aren't the residents of the apartment block still private when they're taken out of the confines of the building and put on the walls of the gallery? In a way, the problem with the discourse of the home as the crucible of privacy is that it assumes that we stop being private when we leave the home.
Yes. Yeah. So. Part of what I'm doing is just making an observation that the courts don't consistently treat the home as this sacred private sphere. The courts don't do it consistently. And so we're kind of left wondering, well, this time will they? That time will they? Does our foreknowledge that utility and quietude are principles upon which privacy is qualified give us some way to predict the outcome? But the larger point is that the home isn't and can't be simply revered as a special place when it comes to privacy. And we don't want courts to simply elevate the home and ignore that they're being inconsistent and that there are other places in the world where we want to have privacy too. Someone mentioned today the fact that if you have the court thought if you put a GPS in someone's car and they're driving around the city, there's no privacy because, after all, you're just driving around the city. But, the courts will say things like, well, but if you bring the car into the garage, now there's a privacy interest. Or, it's okay to put a GPS on a suitcase or a barrel you think might have some dope in it, but once it comes into the house, you can no longer monitor it. That's silly, silly, right? To think that the house becomes some sort of barrier that just frustrates law enforcement. On the other hand, the house is a sacred castle. So, so we want privacy everywhere. When I walk across a city street, I don't want to be harassed by people interfering with my privacy. I'm in a public place. My colleague Helen Nissenbaum often talks about privacy in public, as have I. So it's not about the space, it's about what people need by way of agency and opportunities for reflection and contemplation, as were stressed in the previous panel.
Okay, can we take it over to you? Yes, the gentleman in the fifth row in the blue shirt. Sorry, the microphone. The microphone.
Maybe I haven't understood what you're saying, but it seems to me that the infrared sensors case and what were the other ones? Oh, the GPS case?
Yeah.
They don't turn on the notion of privacy, do they? They turn on warrantless search and seizure.
Okay, so...
Or warrantless search.
Right. So what's the connection between the Fourth Amendment and privacy? The Supreme Court has, for many, many decades now, said that the point of a Fourth Amendment warrant requirement is to protect privacy. So we should understand and can understand and are invited to understand the limitation on the government to search or to seize without a warrant as a limitation that's called for by the expectations of privacy that American persons have. That's the connection.
Okay. The lady at the end of the row there.
I'm wondering if your Kantian self could talk a little bit about privacy in public. And I'm thinking especially of, the Facebook, phenomena of taking pictures of any old person you feel like and posting it on your Facebook page, which turns that person into an object. And I'm wondering if you might speak a little bit to privacy in public.
It is fairly routine and predictable that our courts will say that if something happens outside the house, there's no expectation of privacy. That's why we can have cameras on the streets without search warrant. Why, if someone snaps your picture and while you're in a park or in a movie theater, that you don't have the same expectations of privacy unless they turn you into advertising for a product. You might. And so why do we have privacy in public? And I guess I have over the years marveled at the fact my belief. I believe and have marveled at the fact that many others embrace this belief too, that among the places that we go to achieve privacy are places that are commonly described as public: coffee houses, public parks, museums. And when we're there, we want to be unmolested, left to our own thoughts. And so any kind of practice, whether it's catcalling or whatever, that tends to disturb people who are about their own business in places that are not defined as the home, are assaults on privacy as well. If you think about privacy as not being secluded behind castle walls, but merely being free from attack and interference on personality, there's no reason at all why there can't be a concept of privacy in public.
Yeah, and in a way, the common denominator is the seclusion of the space in your own head. What comes to mind is Roger's example right at the beginning of the day of the guy who takes a leak on the street while he's walking past, and he experiences it as the intrusion. Because actually what's being violated is not an external space, but the space of his own mind.
Yeah, and I mean, putting it that way is okay, although I would also like to not have us think of that privacy is too exotic, something extremely spiritual and beyond our grasping. It's just that we want to be left alone, left to our own thoughts. We want to be left alone. You can be left alone in your castle. You can be left alone inside of Macy's. I mean, and there's not a big difference. Now, maybe there are some differences in quote unquote expectations, because if you're left alone in your thoughts in Macy's, you may have to be asked to leave at 5 o'clock when the store closes, or maybe you can't finger the merchandise too aggressively, or whatever. Maybe if someone does not offend so much if they ask you for what time is it or something like that. But there are social norms that could exist and that do exist that shelter us from too much intrusion and assault, even when we're outside our homes.
Okay, there was a lady, yes, in the sixth row, yeah. And then
I wonder if you might accept, or we might consider a slight reframe of the way we think about this. We speak in this country of rights to free speech and privacy, but in fact our legal system defines them as rights against or from intrusion. And even we have today pretty much said intrusion by the government, by corporations, by our neighbors, by artists. And I wonder if, and by doing that, we do exclude the homeless, for example. We do exclude people who don't have the means to have a home or a space of privacy. And I'm wondering if reframing it as the right to the means for self-realization, whether in the Gandhian sense or some other sense, might be a better way to think about this, so that everyone has a place in which they can have privacy, and everyone has a way in which they can realize.
Yeah, I mean, we could go that route. We could also go the route of saying that even if your home is a cardboard box on Main Street, you can't be molested in that space, right? Self-realization. I mean, I think that your reframing is okay, but I think that someone said they were tired of the word privacy. Who said that?
Kate.
Okay, so I'm not. And I think most people are not tired of the word or the concept of privacy, and are not tired of exhausted by mining that concept for all that it means and can mean. And I think it might mean or have some different connotations than a self-actualization, for example. So while I don't disagree that many of the concerns that we can be talking about under the rubric of privacy might be more inclusive if we talked about self-actualization or self-realization. I'm not prepared to give up yet on the discourse of privacy itself.
Yes, down there.
I was wondering if you could comment on the situations where privacy comes in conflict with First Amendment rights, which is not a usual situation.
Such as the case I talked about today, yeah.
Yeah, but, well, I don't know, about the abortion picketing rights and the ability of the state to limit, to create a free space where patrons from abortion clinics could go without having to confront the First Amendment rights of picketers.
So privacy does often conflict with, what the court calls rights of privacy often conflict with what the court calls rights of free speech or freedom of expression. And so in the case of the abortion picketers, the issue was, what should prevail, the right of the picketers to express their opposition to abortion policies and practices, or the ability of people to enjoy home lives free from disturbance by picketers. And there was sort of a weighing and a balancing there. The First Amendment is very strong, and oftentimes First Amendment interests will win out over privacy interests. I'm surprised by the abortion case because I could have seen it go the other way. That the court find that there's no legal way under our Constitution to prevent somebody from going to someone's street and making loud noises outside their home in order to protest their conduct. So in some ways, the abortion case that I talked about is surprising because we know that so often the First Amendment will prevail. The art case, I mean, I love art, and I'm really pro-artist in so many ways. And in this case, I didn't really lay out the analysis fully, but it was a First Amendment analysis. The First Amendment protects freedom of speech and freedom of press. Art is analogous to press and to expression. Art is therefore protected by the First Amendment. Because art is protected by the First Amendment, other interests must give way unless there is a strong, compelling reason not to. And the privacy of people in their own homes, when they have opened up their shades or not drawn the curtains, is not as strong as the interest in art. And therefore, Svendsen wins and the neighbors lose. That's the way that whole thing
It was interesting, though, that you commented more than once on how gorgeous the photos were.
Yes, they are gorgeous.
Because I would say the gorgeousness of the photos is absolutely bound up with the fact that they're a violation.
Absolutely. And so does the capacity to create beautiful objects overcome any interest in privacy? I hope not. Right? People could do all kinds of beautiful things with us, with our bodies, if they were entitled to. And they have, sometimes to our detriment. We can't let the fact that let's put a blatant kind of Kantian terms. The ends don't justify the means, right. So we have this problem.
Do we have time for one more? Yeah, okay, so we're out.
First of all, this has been a spectacular day, and please join me in thanking Anita.
Thank you.